Please be seated. Our next case is Latavia Jones versus State of Florida Department of Corrections. 15 minutes are allotted per side. It is 20-17-41. You may proceed.
Good afternoon, Your Honors. May it please the Court. I am Mike Weiner from Tampa, Florida, along with my trial counsel, Christopher Costello. From Lake City, we represent the appellant, Latavia Jones. I would like to reserve 5 minutes for rebuttal, please. The facts of these cases are rather tragic, Your Honors. Latavia Jones was a 22-year-old corrections officer who was injured in the course and scope of her employment when she was brutally attacked by an inmate who approached her from behind and choked her and told her at the time that he was going to sexually assault her. She was genuinely in fear for her life, according to her own testimony, and also in fear that because of the circumstances that this individual had the ability to carry out on his threats that he was going to sexually assault her. Following the attack, she was sent by the employer carrier to a couple of different clinics for medical care, and she quickly reached overall maximum medical improvement with a 0% impairment rating from physical.
So generally, the comp law does not allow recovery for psychological injuries unless there's a physical.
Correct.
Injury.
We checked the box here.
But she had a physical injury.
She had a physical injury that required medical treatment.
Thankfully, she's recovered from that.
Correct, Your Honor.
Okay.
And as is the case oftentimes in these post-traumatic stress disorder cases, you get somebody who the physical injuries can quickly heal, and this did check the necessary box under the law of being a physical injury that required medical treatment. And her physical injuries did heal quickly, in fact, within approximately 2 weeks, in which she was placed at maximum medical improvement and released to return to work from a physical standpoint with no restrictions. But at that point, she was referred to psychiatric care. And the carrier then authorized Dr. Liu, a psychiatrist, to examine the claimant on 2 occasions in February and March of 2019. The claimant at that point had complaints of paranoia, flashbacks, depression, nightmares, etc. She was diagnosed with post-traumatic stress disorder, was recommended to initiate psychiatric care, which included medications, and also referred for psychological care. Unfortunately, for reasons that are not really all that apparent in the record, the carrier didn't really follow up after March of 2019 with psychiatric care and didn't authorize psychiatric care for her until February of 2020. Almost 1 year she went completely without psychiatric care. The adjuster had sent her a letter telling her, you got to use your own personal insurance to take care of this, which was kind of cruel and ironic at the same time because she had been terminated and she lost her job and no longer had that insurance to even pay for that treatment. The carrier did authorize psychological care. It had been recommended in March by Dr. Liu, but that didn't get authorized until August of 2019. So she, was without care for a substantial period of time while the employer carrier, for really unknown reasons that are unexplained in the record, was extraordinarily dilatory in providing her the medically necessary.
But that's really not the issue.
That's not the issue, but it does, I think, underscore the difficulty of the situation and how the 6-month limitation can be so draconian.
So ultimately, she received 6 months worth of care, and then it
Well,
stopped.
6 months worth of benefits, Your Honor, correct.
Okay,
She got 6 months worth of indemnity benefits, temporary disability indemnity benefits, which terminated on her about July 25th of 2019. And since that point in time, she's remained out of work from the carrier-appointed physicians, a psychiatrist, Dr. Liu, who said you remain on temporary total disability, a psychologist, Dr. Lovett, who the carrier picked as well and said, nope, you cannot work, you remain on temporary total disability. And even though she remained on temporary total disability after July of 2019, all the way until the final hearing was conducted in this case, she received absolutely no lost wage payments whatsoever.
Well, what does this language that we used in Utopia, Home Care versus Alvarez, where they seem to distinguish or identify this Raza Guevara, what does that mean? Is that binding on us? Was that dicta? I was not on the panel, so I'm not sure why we chose to use that language, but I'm trying to understand
It's a really good question, and I think reconciling these cases can be difficult, but I think that the easiest question to answer and to put the Utopia case in its appropriate box, Utopia was a case that was decided based on the facts and the issues in that case. The facts of that case were the claimant got a 2% impairment rating for her physical disability. And this subject to language, payment of impairment benefits language in section 440.093 does not applied in that case, but does not apply in this case because obviously Ms. Jones never got paid any impairment benefits. So that's number one. Number two, which I think is even more important as far as the Utopia case is concerned, is that The issue there specifically this court decided was, is the 6 month a calendar bank? Or is it a calendar limitation, or is it a bank of 6 months, right? That was the issue that this court decided. So everything else beyond that decision is pure dicta. It is not the ratio desciendi of the case. And we've cited the Aetna casualty case and some other cases that talk about that. You know, what is dicta versus what the actual holding and precedent of that case was. So we would submit that the Utopia case in no way, shape, or form should control the outcome of this case, because all those statements that went way beyond what the issues were necessary to decide the specific issue in that case are pure dicta and have no controlling precedent.
Your contention, although the subject to payment of permanent benefits in 440-0933 conceivably could be ambiguous, we resolved that in Razo Guevara, and that's still good law.
Yes, precisely. And not only did it in Razo Guevara, but again in the Neer decision, right, in which this court upheld the constitutionality of the statutory provision, it went back and cited to Razo Guevara favorably as the 6 month limitation, again, being subject to the payment of impairment benefits. That language in the statute has to mean something, right? We cannot treat it as superfluous language or meaningless language. And our position is it can mean only one thing, that 6 month limitation applies in only one set of circumstances. And that is when the claimant has been injured and the claimant receives payment for a physical impairment. If those boxes are not checked, that 6 month limitation does not apply. Those boxes quite simply were not checked in this case, and there is no factual dispute whatsoever about that. The record is clear. The judge's findings were clear. She was placed at maximum medical improvement with 0%.
You would agree that it's somewhat anomalous that someone who has a permanent injury only gets 6 months, but if someone who doesn't, it could be limitless in theory.
Yeah, I don't know if anomalous. I probably have a lot worse words I might call it, but it's odd for sure, right? But there could be reasons why the legislature could have contemplated that, and I think we addressed some of them in our brief. You know, because perhaps the legislature knew that if we left injured workers, you know, with no physical disability but who remained you know, psychiatrically disabled with no benefits whatsoever, that could never withstand constitutional muster. So that could have been the benevolent reason why the legislature chose to give this gift to people who had no physical impairments, on top of the fact that people who do get physical impairments, right, if you get a 10% impairment rating like I think was the case in Utopia, or actually in Utopia the claimant got 2%, and in Human case the claimant got 20%, you're getting some benefits, right? You're getting some lost wage payments, so you don't have that same economic ruinous circumstance visited upon you as the claimant here had, and under our constitutional arguments as Mr. Westfall had, because when you draw the parallels between this case and Westfall, we would humbly submit they're virtually identical.
Well, I'm sorry, go ahead.
So even if we were to look at the statute and come to the conclusion that Razo Guevara misinterpreted that statute, your contention is that Razo Guevara is an opinion of this court that's still valid law and we're bound by it.
100%, absolutely. And I think Razo Guevara is factually identical. If you look at the opinion itself, it's very clear in the Razo Guevara opinion that there were no impairment benefits paid. The opinion is short, but it contains the succinct facts, and those facts match up identically with the facts of the instant case. So yeah, we remain duty-bound to follow the precedent of this court, and there should be no reason to recede from that. And again, putting this thing in its appropriate box, the Utopia case, Utopia was a case that decided an entirely different issue of calendar limitation versus a bank of time. And for whatever reason, I cannot explain, the court sidestepped that issue and went far beyond and addressed other things that were not before it.
On your constitutional argument, except for the new claim reward for industry, doesn't Neer foreclose the other claims?
Not necessarily, Your Honor, because the facts of this case and Neer are so radically different, right? And I think this court took very careful attention to distinguish Neer from Westfall, right? Mr. Neer actually had been released to return to work. In fact, the psychiatrist who had been treating Mr. Neer in that case, and it's published in the published decision, it reflects the fact that he encouraged the claim that it would be beneficial for him to go back to work, right? That's a huge difference. In this case, Ms. Jones has been told by two different doctors of two different disciplines in no uncertain terms, you cannot go back to work. So just like Mr. Westfall, who would have faced a situation of medical non-compliance by returning back to work because he had been placed on a no-work status, the same applies here to Ms. Jones. Mr. Neer's situation, it was radically different. And, even to take it a step further, if you look at the facts in this case, look at the economic ruination that has been visited upon Ms. Jones because of the operation of the statute. She's now indigent. The judge made a specific finding as to her indigence, that she's no longer able to pay her debts. Ms. Jones herself testified that she now has to rely on public assistance. She's lost her job. She has $2,800 per month in expenses, but no income, and has had no income since July of 2019.
So if we were to hold the 6-month limitation does not apply, what limitation would apply?
Well, in this case, there would be the 260 weeks, right? The legislature has already told us that's what you get for a temporary disability, 260 weeks. And that 260 weeks is the limitation that applies to injured workers who are placed at maximum medical improvement with a 0% physical impairment rating, such as Ms. Jones. I see I'm right on my rebuttal time, so if any other questions, I'll entertain them. If not, I'll sit down and wait for my rebuttal. All right, thank you.
Good afternoon, and may it please the court. My name is Ryan Davis, and I represent the State of Florida Department of Corrections and Division of Risk Management in this matter. Today, we'll be asking that this court uphold the lower tribunal's decision to limit the claimant's entitlement to temporary indemnity benefits to the 6-month period post-physical MMI. The appellant has broken down their argument into two distinct forms. The first being that statute 440.093 subsection 3 does not apply to this case. In doing so, they quoted Razo Guevara as well as School Board v. Huben. Each of those cases make reference that the limitation only applies if permanent benefits are being paid. School Board v. Huben went on to say that the statute specifically applies because impairment benefits are being paid. However, I think the case in front of us today is one of first impression. Each in those cases, the claimant was assigned a permanent impairment rating of above 0%. Here, Ms. Jones was assigned a 0% rating for her physical injuries. Therefore, the employer carrier had no obligation to pay any impairment benefits whatsoever with regard to the physical injury. I think as the court found in Utopia v. Alvarez, said very well, when a claimant attains physical MMI and physical injury qualifies for a permanency rating, the claimant is entitled to and subject to payment of permanent benefits. However, that does not necessarily mean that when no physical impairment is, permanent physical impairment is evident, that those benefits become limitless. The court even went on to say that there is no right to an unlimited indemnity benefits when impairment benefits are not being paid. I believe that the history of Florida law, as well as the statutes currently in place, show that there is a disparate treatment of mental health injuries versus physical injuries. In order to be considered compensable, a mental health injury must be accompanied by a physical injury.
But she has that here, right? I mean, she's got, so that, you know, as Mr. Weiner said, that box is checked, right?
Yes, that box is definitely checked. However, I believe it would be counterintuitive for a 0% impairment, a physical injury that has qualified as not permanent, as opposed to these other cases, would serve to provide an unlimited bank of benefits up to the 260-week bank that is available for all other indemnity benefits, only because that permanent physical injury wasn't readily presentable by the claimant. I think that the point is to limit benefits and not to expand those benefits.
Well, it was suggested, though, that perhaps, given that she doesn't get any permanent benefits, there's a rational basis. The legislature, you know, came up with it for some reason, wanting to provide people that don't get the permanent benefits at least the opportunity to continue with some form of mental health treatment when they're physically recovered, but they're still mentally, you know, impaired from the physical injury. I mean.
Yes, Your Honor. And there's no limitation on the treatment available to claimants who have suffered mental injuries that have been accompanied by a physical injury. The limitation is on the the indemnity benefits that are available to those persons. And in referencing the statute, it states that this limitation is subject to the payment of these benefits. It doesn't say that the limitation is subject to an assignment of an impairment rating. It would seem like the easiest way to get around this would be for an employer carrier to pay a 1% rating, no matter whether that was assigned or not, qualify it as a permanent impairment benefit, and then this limitation would always be sufficiently preserved moving forward. I
Well, you
believe-
seem to be arguing why Razo Guevara does not make a lot of sense, and we may or may not agree with you, but I need to hear an argument that Razo Guevara is no longer effective law anymore, because it says what it says.
I believe it can be effective law. I believe that the limitation only applies if permanent benefits are being paid. However, I believe permanent benefits have to be required to be paid. I think that in Razo Guevara, in School Board v. Cuban, Utopia v. Alvarez, Near v. Lincare, all of the claimants received permanent impairment benefits. They received a permanent impairment rating.
Well, not in Razo Guevara, there was no permanent benefits paid at all.
No, you're correct, Your Honor.
Okay.
There is no reference to the permanent benefits
So-
there.
And that's the case, that case seems to be directly on point with this case, and so if you're saying that we should do something different, you need to talk to us about why this is not good law anymore, even if, it's an opinion of this court, unless we go on bonk, we're gonna follow it.
Well, I believe that while maybe an underlying court's decision, I still believe that the facts of the Razo Guevara case are relevant to the holding and the opinion that were issued. I don't believe that the court would state that the limitation is subject to the payment of benefits if payment of benefits would not be due or owing.
I'm not following you, though. When we said in Razo Guevara, this means the limitation does not apply unless permanent benefits are being paid. Because claimant, Razo Guevara, is not being paid permanent benefits, the statute doesn't apply here. I mean, that's this case, isn't it?
Yes, and it is this case, except for the fact that we have a 0% impairment rating here. And I realize that the impairment rating is not readily available in Razo Guevara, but I believe when the court interpreted the statute in Utopia, although that the issue before the court was whether there is a 6-month bank of benefits versus calendar period, they addressed the statute in its entirety in making that interpretation, even specifically stating that there is no right to unlimited benefits when impairment benefits are not being paid. So in that case, if there is no right to unlimited benefits, of course up to the 260 weeks, then what limitation would there be? I believe that was an excellent question. There's no other statute on point that actually limits any payment of impairment benefits, anything to do with mental health injuries. 440.093 specifically states that this is the statute, this is the section that deals with mental injuries, compensation for those injuries, and although it does need to be subject to the payment of permanent benefits, the non-payment of benefits that are due and owing does not operate to cast a net so wide as to provide no limitation whatsoever to these benefits. As stated, I believe that it's well established in case precedent in historic Florida law that these mental health injuries are treated as less favorable. Now, I believe that the legislator has the ability to modify this, as the court cited to in Near, and they have not done so. There's not been a repeal, there's not been a redaction, there's not been any kind of amendment.
Well, that raises a question. If the legislature didn't like what we did in Razo Guevara, they've now had 13 years to change that, right? And they haven't.
Completely correct, Your Honor. They have not changed anything because as applied to the overall facts in that case, and as legislators able to look at something from start to finish and not just the opinion that was issued, the non-payment of benefits in that case was not proper. The claimant attained physical MMI and they were to be paid benefits. While here, there were no benefits to be paid to Ms. Jones. So there was no opportunity for the employer carrier to pay these benefits. I believe the same argument could be made whether a claimant reaches overall MMI and then benefits are to be paid, which obviously is located in other statutory sections. In 440.15, impairment benefits are not due to be paid until a claimant reaches overall MMI. Here, this is obviously, the cases on point obviously point to the fact that after attaining physical MMI, impairment benefits are to be paid, and that this limitation is to be subject to those benefits being paid if due and owing. I think that's a discrepancy that also needs to be cleared up, and the subject to language in 440.0933 clearly points to the fact that employer carrier is responsible for paying benefits, impairment benefits, if they are due and owing for the physical injury when they become due for the physical injury, but not in relation to any claimant's mental health injury or mental health impairment. And to move on to some of the constitutional questions raised by the
Well,
appellant.
if I could interject just for a second. On the Razzo case, I've got it right here. This is it. It's 3 paragraphs. No facts from what I can tell, other than the fact that there's permanent benefit being paid and there's a request for psychiatric benefits. That's the 2 facts that, I mean, they tell us nothing about anything else, about what the impairment rating was. I guess what I'm getting at is it's, for such a case of, quote, first impression, which they called it, they didn't provide hardly any factual context or even legal analysis other than just a conclusion. You said something, what I'm leading to is you said something about the impairment rating was 0 here, right?
For Ms. Jones' case, yes.
Okay, but the impairment rating isn't identified in Raw, so I assume it's 0 because it's no permanent benefits being paid, but is that necessarily the case?
Given the fact that I could actually investigate that issue, no, it's not the case. The JCC determined there was actually a 5% impairment rating in Razzo Guevara, and that those benefits were not being paid. Now, I agree that.
How do we know that?
Yeah, that's
Excuse
what
me?
How do we know that?
And that is the problem that I am up against now, Your Honors, that there is no way, based on that opinion, that we can ever know that those benefits were due and owing, that there was ever an impairment rating to be assigned.
You're saying there's a JCC order in that case that perhaps is on Westlaw or that's available for judicial notice. Is that where you're getting the 5%?
Yes, Your Honor.
If she had a 5% impairment in, or I'm sorry, Mr. Razzo Guevara, if he had a 5% impairment, why would we say because claimant is not being paid permanent benefits?
Because the statute specifically references that the limitation is subject to those benefits. So because those benefits were not being paid by the employer carrier for the physical impairment, then the limitation does not apply. It would act as to further limit the claimant's entitlement to those temporary benefits if they were not entitled to the permanent benefits when they became due and owing.
So you have a case that tells us that we can look to the underlying orders of the JCC and interpreting our cases or opinions of this court?
No, Your Honor, I do not, and I do not believe that is necessarily proper. However, I believe the brevity of the Razzo Guevara case leads a lot to be determined as to if, for example,
So it's short, but it posits a proposition of law. We don't have to follow that proposition of law because there's not a lot of factual backup for it?
I believe if
How do we get there? I'm trying to figure out where you're trying to lead me.
Yes, Your Honor. As in each of the cases previously cited, there are distinguishing factors that can allow deviation from case precedent via stare decisis. Because there are no clear facts outlined in the Razzo Guevara case, I believe that there can be distinguishing factors here between Ms. Jones's case, for example, that there is no impairment rating assigned other than 0%. So while it would not be proper to completely disregard the precedent, I believe that there are extenuating factors that allow for a more in-depth or even a different interpretation of the statute or a different outcome based on the facts as applied to this matter.
I don't have Huban, School Board of Lee County versus Huban in front of me, but didn't we say the same thing in Huban as we said in Razzo Guevara?
Yes, in School Board Huban, it actually did identify that there was a 21% impairment rating for the claimant, and I believe the court specifically stated that it is obvious that the statute applies because impairment benefits are being paid.
So the converse would be if impairment benefits are not being paid, the statute wouldn't apply. I mean, that's...
Correct, but I believe there needs to be a distinction drawn between
And they
impairment.
cited Razzo Guevara as the precedent they were following here.
Correct. And I believe that what needs to be distinguished here is the difference between impairment benefits being paid and impairment benefits being due and owing. For example, in these cases, there were impairment benefits that were due and owing, at least in School Board v. Huban. So therefore, the statute applies because they're being paid. If there is an impairment rating in School Board v. Huban, which there obviously was, and the employer carrier declined to pay those benefits, then I believe that is the basis for the statute no longer applying, because it would no longer be subject to the payment of those benefits.
Okay, let's say that we find that the 6-month limitation does apply. They have other arguments, largely constitutional arguments, but I think that we have at least an acknowledgement by counsel that Neer knocks out a lot of those. The ones that he said remained, will you address those?
Yes, Your Honor. So I believe Neer v. Lincare would address the due process and equal protection arguments, and I also believe it would address the argument via Kluger for a reasonable alternative for tort litigation, leaving the violation of the right to be rewarded for industry. There is no dispute that Ms. Jones was out of work following her treatment with Dr. Liu in March of 2019. However, she was then presented an opportunity to return to the psychiatrist. Dr. Liu refused to treat Ms. Jones. Dr. Liu refused to have her deposition taken. Dr. Liu later terminated her physician-patient relationship with the claimant. Then when the employer carrier authorized a subsequent doctor, Ms. Jones failed to appear to that psychiatrist. With regard to the right to be rewarded for industry, I believe that Ms. Jones applied for jobs and entered into the collegiate system in order to further her education, in order to re-enter the workforce. I do not believe there was any necessarily a right violated with regard to return or reward for industry, as she was afforded indemnity benefits during the period where she was out of work.
If I understand the facts, she was assaulted at work, and two psychiatrists told her, psychologists, I'm not sure which, told her that she was not, because of her psychological, not to return to work, and she was terminated by the department because she was not able to return to work. Is that correct?
Yes, Your Honor.
Okay.
Yes, the psychiatrist, Dr. Liu, took Ms. Jones out of work as of March 2019. In August, Dr. Lovett, the psychologist, placed her on no work restrictions. However, shortly thereafter, as you will find in the record, Dr. Lovett recommended that the claimant return to work, as referenced in Neer. It was in her best interest, and she was actually applying for jobs during that time.
Okay.
So
You're-
based on that,
You're over time, so can you wrap it up very
Yes.
quickly?
Thank you, Your Honors. So based on these arguments, the employer carrier wishes, or excuse me, the appellee wishes that you find that the lower tribunal's order is proper and deny any additional benefits. Thank you.
Thank you for your argument. Rebuttal.
I kind of want to begin, because I somewhat bristle at the notion that the benefits can be limitless, the temporary disability benefits that the claimant receives. That's not the case at all. We have a statutory limitation, Your Honor, as you had alluded to, of 260 weeks. And the carrier here sort of chose their poison, right? What's the reason why it would have taken them 11 months plus to authorize an alternative psychiatrist to Dr. Liu when Dr. Liu would not see her anymore? Why did it take the employer carrier almost 6 months to authorize a psychologist after it got the recommendation from Dr. Liu in February of 2019, right? This is supposed to be a self-executing system where benefits are promptly and efficiently delivered to the injured worker, and it didn't work like that. So the only reason why there may be an extended period of disability benefits, really, it's the fault of the carrier, because they didn't honor the self-executing the nature of the system and provide the benefits they should have provided in a prompt and efficient manner, as Florida Statute Section 440.015 tells them they're supposed to do. So, the carriers are sort of victimized by their own, lack of diligence in terms of any protracted period of disability benefits up to that 260-week limitation. The comment that, she may have looked for work elsewhere or may have, started school, that's irrelevant to the constitutional arguments under right to be rewarded for industry. It's irrelevant really to all the facts of the appeal. The facts of the appeal are that she has been told by a psychiatrist and a psychologist, who both have been authorized by the employer carrier, that you cannot work. And she has heeded those instructions. In terms of the carrier's argument that, Razo Guevara shouldn't apply because, the underlying facts in the record may suggest that she was assigned, the claim that there was assigned an impairment rating. That's not part of this opinion. And I think that the Edelman-Steele versus Winter case directly addresses this. It says, if there is an opinion which gives the facts, the first point to notice is that we cannot go behind the opinion to show that the facts appear to be different than the record. That's this court's binding precedent for goodness, 30 years now, or 20 years now that it's held that. And so it would be improper, as the appellees have suggested, to go behind the facts of that opinion and see that there might have been things otherwise. Plus, even if you're inclined to sort of break the rules and give the appellees a chance of wanting to go behind the record to see what's there, while the claimant in the underlying order, it suggests he was given an impairment rating in Raza Guevara, it was never suggested it was paid. The statute very clearly says subject to payment of impairment benefits. The 6-month limitation kicks in, not subject to an impairment rating being assigned, and that's a critical difference. The appellees also mentioned that, if the carrier wanted to skirt the issue, they could just pay a 1% sort of arbitrarily, but there would be no basis for that. Benefits are to be paid when they are right, due, and owing based on recommendations from an authorized doctor. And it would be entirely improper for a carrier just to pay a 1% rating to avoid the 6-month limitation, so we would submit that's a specious argument. It would be the appellant's humble request that your honors would reverse the final order of the judge of compensation claims. The easiest solution to this problem, which avoids the constitutional conundrum that's obviously inherent herein, would be to uphold that Raza Guevara is good law, that under the plain language of the statute, which this court is duty-bound to follow, and also under the doctrine that, a reviewing court cannot treat any portion of legislative language as superfluous or meaningless, we have to give this phrase subject to the payment of impairment benefits meaning. And the only way to do that is to hold, as this court did in Raza Guevara, that phrase only is triggered, that 6-month limitation only is triggered in circumstances where impairment benefits are actually paid based on a physical injury that is assigned by an authorized treating doctor. And because that never happened in this case, there is no evidence that would ever happen in this case, this court should reverse the judge of compensation claims and order him to provide psychiatric temporary partial total disability benefits up until the point where she reaches maximum medical improvement or the 260-week limitation applies. Thank you, Your Honors.
Thank you. We have no other cases on the docket for today, so we will stand in recess until 2 o'clock tomorrow.